An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
United States versus Virginia, 1996. The Virginia Military Institute, VMI, is a public college in Virginia. VMI's mission was to produce, quote, citizen soldiers. Through the so-called adversative method, VMI instilled physical and mental discipline in its student body. The students lived in Spartan barracks, wore uniforms, ate together, and had no privacy. Since its founding, VMI only admitted male students. The United States filed suit against VMI on behalf of female students who could not apply to the college. The Fourth Circuit Court of Appeals ruled that VMI's admissions policy violated the 14th Amendment, but suggested that the university could cure that problem by establishing a parallel program for women. As a result, Virginia opened the Women's Institute for Leadership, or VWIL, at Mary Baldwin College, a private women's college. However, VMI and VWIL did not offer the same programs. Justice Ginsburg, who wrote the majority opinion in Virginia, stated the question presented:
whether Virginia can constitutionally deny to women who have the will and capacity the training and attendant opportunities VMI uniquely affords, training and opportunities the VWIL program does not supply.
The court answered no. VMI's admission policy violated the Equal Protection Clause. The vote in Virginia was 7-1. Only Justice Scalia dissented. Justice Thomas recused because his son attended VMI. The court acknowledged that there are, quote, inherent differences between men and women. However, the court found, quote, such classifications may not be used as they once were to create or perpetuate the legal, social, and economic inferiority of women. Justice Ginsburg stated,
state actors may not close entrance gates based on fixed notions concerning the roles and abilities of males and females.
Study guide. Are there ever valid bases for the government to treat men and women differently based on biological traits? We previously discussed the standard of review under intermediate scrutiny. A quasi-suspect classification, such as gender, will be upheld if the government can show that its law is substantially related to an important interest. The standard is called intermediate scrutiny. Justice Ginsburg described the test differently.
Defenders of sex-based government action must demonstrate an exceedingly persuasive justification for that action. To make that demonstration, the defender of a gender line must show at least that the challenge classification serves important governmental objectives and that any discriminatory means employed is substantially related to the achievement of those objectives.
Study guide. Did the Burger Court's application of intermediate scrutiny require the government to provide an exceedingly persuasive justification? This new standard would become significant for future sex discrimination cases. The court held that Virginia has shown no exceedingly persuasive justification for excluding all women from the citizen soldier training afforded by VMI. Ultimately, Justice Ginsburg concluded that, quote,
under the Equal Protection Clause of the 14th Amendment to the United States Constitution, Virginia may not reserve exclusively to men the educational opportunities that VMI affords.
And there's only one possible remedy. Women had to be admitted to VMI. Justice Ginsburg observed,
to afford genuinely equal protection, women seeking and fit for a VMI quality education cannot be offered anything less.
Her opinion echoed the separate but equal principle that was established in Plessy v. Ferguson and rejected in Brown. The separate program at VWIL was not an equal substitute. Study guide. Can you see how the canonical versus anti-canonical status of cases can work to influence how the court reasons? Justice Scalia was the lone dissenter. During oral argument, he contended that VMI excluded women to ensure that men could be trained in the adversative method. The policy, Scalia claimed, had, quote,
"That has nothing to do with whether women can take the heat."
Rather, forcing VMI to admit women
would interfere with the kind of relationship among the students that produces the adversative method.
Furthermore, he claimed that the majority opinion did not faithfully apply the court's intermediate scrutiny precedents. Instead, he wrote, "The new test is indistinguishable from strict scrutiny." Under that conventional test, Justice Scalia contended VMI's policy was obviously valid. Quote, "It is beyond question that Virginia has an important state interest in providing effective college education for its citizens. That single-sex instruction is an approach substantially related to that interest should be evident enough from the long and continuing history in this country of men's and women's colleges." Study guide. After VMI, is there any difference between the judicial scrutiny of classifications based on sex and classifications based on race? Should sex-based classifications always be treated the same as race-based classifications? Although Justices Scalia and Ginsburg often found themselves on the opposite side of cases, they remained close friends during their entire time together on the court. Here, they found themselves on the same side of an elephant during a trip to India.